So let me start off, and really the point is, for you to pose a question or share a thought, but I wanted to just get us started by picking up on a conversation the Chief Justice and I have had through a couple of different conferences and things that she's tried to stimulate many in the legal community, including law schools, to think more about, and that's access to justice. But in particular, the debate very quickly, moves into how we pay for legal services and what the profession can do, and pro bono versus legal aid. And there are lots of innovations coming, particularly with that middle class group that doesn't get access to legal aid and yet can't comfortably afford legal representation, particularly in areas like family law where the stakes couldn't be higher. And one of the things we haven't had a chance to talk directly about is what more law schools can and should be doing, because this is a school that holds itself out with great pride in leadership, and we celebrated 40 years of clinical legal education, which was the dawning of that era, and at Parkdale and CLASP, and it's a point that if there is a way forward, we would want to lead that way if it were at all possible. Do you see that as one of the answers, more pro bono clinics from law schools or students filling those gaps?
I think those are all good things, but I think the most important thing for me that a law school could do would be to engage in a conversation about why people are going to law school, what they can do with their lives. Is it just about making a lot of money? Is that what they want to do? Or is there a greater calling as a lawyer? Really, you are the purveyors for the future generation of justice. And people to get justice have to go through you. So I would like to see that as part of the message that goes out in many different ways through many different channels to first year students, and is sustained, that being a lawyer or a law student, being a lawyer or some other career that you may choose as a result of your studies is not just a way to make a living. Hopefully that will happen, but it is a way and carries with it a responsibility to see that you provide access to justice to people throughout your life. And if you don't start that with that attitude in law school, I don't think it will happen very easily later. So one of the problems with access to justice is, entrenched attitudes at high levels where people just don't get it. And I think if those people had thought about it in law school, they might be getting it more easily now. So I think that I hope that this idea that access to justice is important, and that there's a responsibility of lawyers and to provide it becomes one of the pillars of legal education in law schools. And then from that, of course, then it makes sense to have pro bono clinics and to have other legal assistance and social programs, and it all fits together. Otherwise, it's almost as though, well, we've got this curriculum, and then we'll tack on a few legal aid and pro bono projects to make it look good. I guess my message, what I'm trying to say rather inarticulately, is that rather than just have this tack-on process, this should be part of the systemic approach, and so that everything flows naturally. And then I think it'll happen. And then, of course, there is the huge contribution that student groups actually make to furthering access to justice. That cannot be overlooked.
No, it's a particular irony at Osgoode, because we started off, of course, as a place where apprenticeship, learning by doing, was the theme, and there was a reaction to that by those who wanted to see university-based legal education as one about ideas. And I like to think that our embrace of experiential learning, of access, is a nice way of coming full circle back to a tradition of learning about law and action, but without losing that commitment to ideas and intellectual engagement.
Absolutely, because if you go back and think about what justice is and has been through as long as we know humankind, it's a very old idea. I like to say people are kind of hardwired for justice. Whether you go to the Greek plays or the Jewish history or wherever you go, you see these justice themes coming through. And so it's big ideas, but it marries very well with practical hands-on.
Of course, if we weren't wired for injustice, the justice business wouldn't have much to do. So maybe it's a complicated story. But let me turn it over to any one of you that wanted to pose a question or share a thought. And this is really your time. And after a minute or two, I'm going to go get the drinks next door and start serving. But who wants to chime in first? Exactly. You couldn't have a less intimidating.
I'll ask. There's been a lot of criticism recently about the diminishing level of civility in the legal profession, and I'm not sure if that's something that translates up to the level of Supreme Court, where it's something that you see on a regular basis as part of hearings, but it's certainly something that seems to be translating as becoming more commonplace at the trial level. And even outside of the courtroom environment, just behind closed doors, settlement talks, and other interactions between legal professionals. What do you see as the best way of addressing this lack of civility? How do we improve that? And what are things that we can do as budding legal professionals to make sure that we flip this trend on its head and actually reinvest in a level of professionalism?
Yeah, well, that's a great question, Steffi. I think I've given a few speeches on civility too, and so have other people. When the American Bar Association had its national meeting here in Toronto, the president chose that as his theme when he spoke to the people. And what I have seen is over what has been a long career, is a certain hardening of a tendency toward a more adversarial stance. There's nothing wrong with being a strong advocate and a hard-hitting lawyer, but you need to maintain those professional relations, and you need to understand that there's just because you don't agree with the submissions or the cause across the way, that doesn't diminish the professionalism and the civility that is the real strength of the bar. So I don't know what the magic bullet here is, probably isn't any, but I think we need to teach it in law schools. Obviously you've been getting the message here. We need to talk to the profession about it, as the ABA president did. We need to understand that we cannot be effective if we are uncivil. You look at the best lawyers, the people who really have reached the top of their profession, and they're not these people who are sniping and being angry and insulting. They are true gentlewomen and gentlemen, and they have understood the message of civility and it's become part of their success. So I think that's a very good way to sell it. If you are uncivil, you will not have the confidence of those who are working with you and under you at a very profound sense. And as a consequence, you will do a less effective job. There's a little bit of a show sometimes that goes on for clients, I think, at some levels. And I think that may be tempting for some lawyers to buy into that, and I'm going to really show this person I'm a fighter, I got true grit here. I saw that movie.
Two guns blazing.
Yeah, but that's not our model in Canada. And even in the United States, the best lawyers are the civil lawyers, and I know a lot of them.
Although the real challenge for legal ethics can be, what about the really good lawyer who isn't civil? In other words, occasionally there will be someone who gets good results, and the challenge is that notwithstanding the good results, it still can't justify diminishing the bonds of professionalism. And I think you're right. Overall, the good ones tend to be the ones.
Judges don't like uncivil lawyers, and it's amazing how it kind of comes through. We had, you can have hearings where the issues are hard fought, but you almost know that each of their lawyers go away and they're good friends. They each understand their case, and they present it in a beautiful way, and all the points are made, and the judge, that helps the hearing. Unnecessary barbs don't help the hearing, and too aggressive a plaidoirie, comme on dit en français, too aggressive a presentation is going to turn the judges off. So I don't know, they may succeed because they've got a good point, and the judge is going to do what she or he should do. But But I wouldn't think, if you're on the other side of such a thing, I would not let down my standards. I would continue to be civil and don't get sucked into that vortex where the rhetoric and the animosity and the aggression just keeps ramping up.
Some other thoughts or questions?
I have a question.
Yes.
I was wondering if you could speak a little bit about the role of feminism on the bench. And I've read about what you've said about how necessary it is for us to have more women judges.
Mm-hmm.
But I was wondering if you could speak particularly to that idea of equality through feminism and whether it can
What do you mean by feminism? Because I know there are about 50 definitions.
Well, when I talk about it, I mean the advancement of all those who are socially marginalized and believing that individuals should have equal opportunity.
Well, I believe that our institutions should reflect society generally. So they should not be consisting of men in gray striped pants of a certain age, you know. I've told this story and so many times, but you may have heard it. But when I was a very junior judge, one afternoon I had a case about the division of property in a matrimonial situation. And it was very simple, and the parties had a townhouse, and they had agreed on custody, and they had a few assets, and the question was how it was divided. So the wife was there, and she had a woman lawyer representing her. The court clerk was a woman, the court reporter was a woman, and I was a woman, and the husband was representing himself. And so we went through the first part of the case, which was the wife's, and that was fine. He didn't cross-examine much. Then it was his turn, and I invited the husband to stand up and give his presentation, and he seemed to be having some trouble doing that, or didn't want. And so I said, I thought it was because he didn't have a lawyer, and said, you don't need to worry. This is quite a simple matter. I really just need to know your side of the story and how you respond to the various points that have been put up. And finally, he stood up and he said, well, frankly, Your Honor, I feel a little outnumbered. And I realized it wasn't about not having a lawyer. It was about the fact that he was the only man in there. So I said, well, that won't be a problem. I can assure you that, I'll do my best to do justice, and I don't think gender is going to play into this. I can assure you it won't play into it. And so he did, and he gave his case, and everything was divided 50-50. And I went home that night, and then I thought, well, that was a pretty boring day, And then I reflected, and I thought, that was a very interesting day, because I learned something very profound from it. I thought, how many women throughout how many generations, if they could get to court at all, in spite of all the obstacles that might be put in their way, would stand up in a courtroom and feel a little outnumbered. And I think that story perhaps gets through the answer more than any of the generalities. And it also applies to other minorities. The courts belong to the people, and they should feel that they're reflected there. Now, we have had a lag in getting enough women on the bench. We're about 34-35% in that range, and certainly in getting ethnic minorities on the bench. But the way our system is set up, judges, and I think there's merit in this, are chosen from the ranks of senior lawyers. So it takes time, and now that we're seeing more women in practice and so on, we're seeing more on the bench. And similarly with ethnic minorities, the first, second generation phenomenon was not to go to law school. I mean, it was, parents thought it was much better if you became a doctor or this or that. But now we're seeing a lot of ethnic minority people going into law school. There's a particular problem that happens with women that still is not solved, and that is there's a high dropout rate in the profession. So those people go off the track that you would normally follow to become a judge. And this needs to be addressed. Many people have written about it. I hope it is being addressed. but there is a tension between the Edwardian model of the firm, where Papa went off to work and everything was looked after on the domestic side, and had total freedom to work 14 hours a day if he wanted to, and the way men and women are living today, which is more shared responsibility. And it's not just women who are complaining about this, but it still happens that more often than not, if the crunch comes in the family and somebody has to stay home for a few years, then it's the woman rather than the man. I'm not sure why that is, but it is. And then the second thing is, we haven't built the right on-ramps. When women go back, they're often penalized. They're put back a few years, and I don't understand law firm structures, so I really can't pronounce in a definitive way on them. But it seems to me that we need to find ways for the profession to accommodate what we think is a good thing, which is family, children, and giving to your community.
That's great. Any other questions?
Sure, I'll ask you a question. So Chief Justice McLaughlin, you've been on the court for a number of years, and the world's obviously changed in that time. Canada's changed in that time. Do you think the role of the Supreme Court of Canada has also changed since you've been on the court?
Subtly since I've been on the court, there have been some real landmark changes historically. The first was, and this you people weren't even near being, your parents weren't born, but the abolition of appeals to the Privy Council in 1949, and effectively the last appeal from Canada to the Privy Council in 1950 was a huge change. And in the years that followed, you see a very different attitude emerging in the justices. Many of the justices, for example, Justice Laskin, Chief Justice Laskin, Justice Dixon, later Chief Justice, and others started, and with the cohorts of more conservative colleagues, started developing a unique Canadian approach to the law. It wasn't a seamless ascent. There was lots of back and forth, but we saw, if you trace this, Professor McCormick does this, you see the citations for English to English jurisprudence going down, and citations to Canadian jurisprudence and sometimes other jurisprudence from other countries coming up. And
the first citation to academic writing, which
absolutely,
was only in the 60s.
Chief Justice Dixon and
right.
Laskin brought those innovations in. They were keen to look for ideas wherever they were, and so it was a fresh, open idea. Instead of just having to follow what was done in England, there was this fresh, open idea, and it was accompanied by growth in Canada. And the Trudeau opening up, the Just Society, the idea that we had the right to have our own we needed our own unique jurisprudence for our country. So that was the first big breakthrough in the years that followed. And then, of course, we had the Charter in '82, and that was another huge change for the Supreme Court. And it was such a big change that the Supreme Court had to actually change all its procedures, bring in limited time hearings, change the process so that a lot more was done on paper and the judges prepared in advance instead of just coming in and listening to a long story for 2 or 3 days. It just wasn't possible. You were a clerk, not quite then, but in the later years. And
actually, there's a picture of all of us behind you having some bad hair days in 1992, and I think it was Michael Bryant who was one of your clerks then, and Mary Jackson and Andrew Foley.
Yeah, wonderful. So anyway, there was such a heavy load with all these charter cases, and I still don't know how the court got through all those cases. They'd hear up to 100 or more cases a year, and most of them were really tough cases. And it was up to the court to lay down the framework, the foundation for the content of the rights and how Section 1 worked and all that. That was huge jurisprudential task, and I think I wasn't there till '89. I think that those people who worked in the '80s really did, on the whole, a fabulous job with very few missteps, and laid out a conception of the rights of Canadians, but more important, a conception of the role of the court, which bothered a lot of people, and there was rightly a democratic conversation about that. People said, well, where are these activist, quote-unquote, judges coming from, and why are judges deciding these things? Well, it was true, judges had never decided them before. Judges were mostly looking at torts and contract and criminal law in a very narrow sense. And now suddenly judges were saying, well, this is what we think about this abortion law, or this is what the charter says about this criminal law, and this law may have to fall because it's not compliant. And so this was a huge revolution, and we had a lot of conversation about it. I think there were those who argued that this wasn't a good development, but I think it was a natural, myself, outcome of the charter. And so that was a huge change in the role of the court. And we're still a little bit in that, but I think my own perception is that there's been a mellowing in attitudes. People now accept more that the charter has a place in Canadian society, and that judges have a role under that, and that we have pretty good jurists for the most part on our courts, and that they're trying to do the right thing. And certainly there's public debate about decisions, as there should be, but that the courts do have a legitimate role. So I think that's sort of where we are now. I'm hoping we can just consolidate a little bit before we have another big jump. I've referred to two of them.
Well, when you mentioned activists, judges, it reminded me of a conversation Jason, Sasha, and I were having, who is both our videographer and a law student here. He came with me to do an interview of Chancellor McMurtry, former Chief Justice and former Attorney General, and of course you'll hear him later. And we're talking to him about the role of lawyers, and especially in the charter era, because judges can't stand up for the rights of others in the way that you can when you're a student, you can when you're a lawyer. And he was reflecting on his regret that he didn't do more during the FLQ crisis in 1970. And we were interviewing right at that 40th anniversary time of reflection. And the Pakistani situation was unfolding with a Chief Justice under house arrest, and lots of ferment that lawyers should organize to do something. While we're here, there's an Occupy Toronto happening, as there is in Ottawa and Wall Street and so many other places. So I'm curious if you have that sense of, in this charter era, that lawyers have also a special role to look in their communities, look around the world, and not just say that things are as they are and there's nothing we can do, but take up that sense of leadership that lawyers are uniquely qualified.
Well, I think so.
to do.
I mean, lawyers are so uniquely qualified in their skills. The skills of being able to look at complex situations and complex and bulky sets of data and material and figure out what are the important points. That's what your legal education couldn't tell you, to train you to do. And then the ability, the second ability to articulate these things and get the message out. And the third ability to really work with others. I think a good legal education does all of those things. So you come out with some very special skills that people who go through other educational routes may not have. They may not have this ability to look at a whole bunch of material and say, this is the point, and these are the important things, and these are less important. They may not have the ability to actually express those ideas verbally and in written form that lawyers have, law students have, and they may not have the ability to work with and other people. Now those are skills you will get from your law education. I can see by what you're already doing that you're well on the way. And those are skills that you need as citizens of Canada to take into the world now, as you are doing, and in the future. And so society needs its lawyers. There's all these lawyer jokes. I think they're dying down a bit in the United States. And there's an idea out there. I've read articles, suggesting that lawyers are drones on society. And I get so angry because I think this is the vital role in a democratic society. And lawyers are probably the best suited. And the only other people see little pieces of the pie, and that's all part of democracy too. But the lawyer well-trained can look at everything and put it together and decide what should be done. Not that you're all going to decide the same things. That's right. That's not what you want. But you have those skills, and so you need to. Democracy is a fragile thing. Our institutions are fragile things. So we need you. Our society needs you out there doing things.
I think that also reinforces that, there's lots of different views in society. The law school, at least all the ones in Canada, are public institutions, and I know that's something that is taken seriously around the table. And please help yourself, by the way, to little spoons filled with treats and usually small burgers. And we probably have time for just a couple more questions or comments before we've got to whisk the honored guests down to the new courtroom.
Yeah,
Great, absolutely.
yes.
I don't know whether they talk about the small piece of pie and everything else like that, and as a former student and reading the cases and the head notes, et cetera, I'm wondering whether there's any thought in your mind as to what do the judges of the Supreme Court do after they've heard a case? Because this is what you were wondering, which was a normal thing that I used to go through, and I say, how did they ever get to that?
So this is the rock, paper, scissors part, or is this deliberations, or what?
Oh, I study out of the head notes. But I mean, I think
Well,
it's interesting.
I think we come into court having read all the judgments and the factums, and with a law clerk memo probably giving the pros and cons of the different points. So we use the court process to ask questions and explore and so on. Then we go out and, I think you know this, have our conference and discuss the case, and generally out of that you get some sense of where people are, and at the end of a couple of weeks someone is assigned to write a judgment, and they do. But that's just what we do is a lot of thinking, quite a bit of talking, and discussing the different issues. And that brings us to wherever we end up. And we have a fairly high rate of consensus, but there are cases where it just doesn't happen, and that's fine too. There are different views in society, and there are different views on the court. Everyone has a right to dissent, and as Chief Justice, I would never, people sometimes say that, I'm hard driving for consensus, but I don't see that as the way I operate as a Chief Justice. I'm not in there twisting arms saying you've got to agree with this or that. I never even get involved in that. I would not do that. But what I do try to do is encourage people to talk and exchange. And then usually they can work out a lot of things. Sometimes they can't. Sometimes the differences are very, very firm, and they see things in a different way, and that's part of our process too, and so I respect that. So I don't know if that really answers what we do, but different judges obviously approach their work in slightly different ways, but those are the commonalities.
Same sort of idea, but how do you choose what cases come to you? How do you make the decision when to address the different issues?
Well, we just look at it on a application by application, case by case basis, and we under our act we have panel. The choice is of a panel. That's a remnant of historic times when the judges used to sit on the bench in panels of 3 to hear these things. Now we have a paper process for the most part, and but we still have the panels. So when I go back to Ottawa and go to the office tomorrow morning, I'll probably have about 3 or 4 leave applications that my panel is looking at, and I'll go through the paper material and I'll make a decision as to whether we should grant leave or not. The main criteria is that the case has to raise an issue of public importance. And that means that it has to be of importance to more than just the parties. It has to be important to the law in general and how it evolves, or perhaps it's a very contentious social issue, or perhaps it's an issue where different courts of appeals in different parts of the countries have taken a different approach to, for example, a particular criminal code issue. And so if we see that, we think, yes, there's some potential disqualifiers. we look to see, after we've seen whether there seems to be an issue, whether that issue actually arises on the facts. Because sometimes parties who want to get leave will, say this is a great issue, it's an important issue, and it sounds like it.
Perish the
But
thought.
then you look at what the trial judge decided, and you look at the way the case has gone up, and you realize that you probably won't even get to that issue, and you'll get bogged down in a rehash of the facts. Our court is not there as a correction of errors court. That's the job of the Court of Appeals throughout the country. If there's been an error made in the trial, at the trial or application level, then the Courts of Appeals sort that out. But we are there to deal with the questions of law.
And there's one piece of that story, though, that often puzzles students in class. And as you know, I teach administrative law, and so in that class we look at the duty to give reasons a fair bit. And this is one of those rare areas, and it's not in every case. Occasionally reasons will be given, but the normal course of deciding leave applications is simply to indicate if it's granted or denied, with costs or without. And I think it was former Justice Frank Iacobucci was at a event, and this question was posed to him. He said it's the one area where you're not so sure you want to bind the next generation of judges who may come after you, that there's something discretionary in a way that wouldn't work as well if you had 5 pages of reasons with every
Well, that's probably true, and I think it's very true. And we then, I should take all these applications in one way or another. I won't bore you with the details, but they come before the whole court. And we once a month look at all the ones that have been proposed to go forward or that somebody thinks might go forward, and we talk about it. So it's really the decision of the whole court in the end. And if 4 people or 3 or 4 people really want to hear it, then there's collegial deference. You say, well, if my colleagues want to hear this, maybe there is a point there. But what the dean was just saying is very true. But there's another aspect to that, and that is that if you gave reasons, they would become a subcategory of precedents. And you already see it in the little asterisk, leave to appeal denied, on an Ontario Court of Appeal case. And what they're trying to say when they say that is the Supreme Court agrees with this. But if we gave reasons, then you'd have another, not only would it increase our workload to the point where I don't think we could do it at all, but that's not the point. I don't think it would add much to the system. I think that there are courts of appeal there, and if indeed it's possible for a court of appeal, if they wanted to go further, to say it should go further, and we look at that. It's very rare that they have the power to send it up to us, in fact. But it would not be helpful, in my view, apart from binding other generations. It's this whole idea that the leave process itself would become a part of the stare decisis, and it would bind future judges. Maybe people would argue it before all the courts in the country. This is high authority, when it hasn't been given that consideration. I mean, before we decide something, we agonize sometimes for many months, and those leave applications go pretty quickly, and it may be refused because the particular point hasn't been well developed in the courts below. Well, that should not stand as a precedent. So I'm very against any idea that this would be used, that we give reasons. And if we do, there have been a few instances, very rare, where a dissenting judge has said, I feel so strongly we should have granted leave that they've given dissenting reasons, but nobody's responded to that. So
well, those are good days for law professors. We take out our but maybe on that, let me ask you a last point, and then we'll have to break, which is, since you were a law professor, since this is such a familiar terrain being in academic settings, and obviously we're at a time of great change in legal education and law school, if you were to cast your mind forward 10 years from now, and we run into each other, as I hope we will, and you say, whatever happened to that promising looking group that I spoke with on the building celebration, how would you think we should measure success? In other words, is it sending them all to be your clerks? Is it going off to be litigators?
There's no one
how would you do it?
I mean, I think what people will end up doing is very much a reflection of their own values and personalities and a number of other factors. But I would just hope that everyone uses their talents and the great education they're going to get to make society, it sounds very bland, but to make society a better place. And
Well, you know, it was our alum, former Premier Bill Davis, who coined the phrase "bland works." So I think there's
In
probably,
politics.
well, maybe there's something aspirationally Canadian about that.
Yeah,
Exactly.
yeah.
No, it's great, and maybe I don't know if we can squeeze around, maybe get a picture before we have to go, or Dave, did you want to?
James just had one.
Oh, sure.
question. Is that okay? Just-
Yeah, let's absolutely. The
Sorry.
last word should go to one of our students.
Sorry.
No, this is good. This is your turn.
Mateen Sawson opened the door, but I was just wondering what you thought about Occupy Toronto and what you think that movement means.
Oh, I haven't settled views. I mean, I think it's very interesting. I'm in no better position than any other citizen, but it's interesting that democracy shows itself in many different ways. And one thought that struck me was I think it's good that in the United States, where this has been such a big thing, but also in our country and so on, that there is the liberty for people to get out there and express their views. That's the kind of society I hope I will live in, and while it sometimes looks a bit messy, etc., physically and politically, it's the only way I think that societies can ultimately move forward in harmony without revolutionary breaks and that kind of thing. There has to be this constant dialogue going on in society. And quite frankly, I was surprised that we hadn't seen more, this isn't me, I have to be very careful not to be political, but just as a distant observer and having nothing to do with the law, looking at stats in the United States, disparities of income and so on. You know, we all know Keynes said, you know, you keep capitalism going by making sure that people have jobs, and that and economists have been saying this for a long time. So I'm not at all surprised that at some point the dialogue starts happening in different ways, and people who are upset and concerned about various issues, who can't get jobs or who feel that there's too much disparity between the rich and the poor, are going to bring it to the fore, and then hopefully, ultimately, we'll get some response and we'll move towards solving those problems before you reach a point when it becomes sort of one of those cataclysmic revolutionary breaks that you see in less free societies, such as those in the Middle East, where we've been watching the Arab Spring, and in some cases, in many cases, a lot of tragedy that goes along with those people trying to change or express their disagreement with what's happening in their society. So I think it's good to have these open expressions. Of course, I don't condone violence and that kind of thing. No one does.
Well, I know you're going to be leaving via downtown later this afternoon. If you don't get caught in the midst of a marathon, you may find yourself with a placard saying "Justice Now" or something to that effect. So,
all for that.
but, thank you so much for sharing this time with us. We're going to head down in a moment. Please join me in expressing our gratitude. And don't let any of those small burgers go to waste. But,
It's been a great pleasure meeting with you all. Thank you.
Thank you so
Good luck.
much.